Indemnity Company. It is 24-0717. While you make your way up, I'll introduce myself. My name is Judge Nardella. Joining me on the panel today is Judge Brownlee and Judge White. As I'm sure you all know, both appellant and appellee will get 20 minutes per time, 20 minutes to make their argument. Counsel for the appellant also has the privilege of rebuttal if they would like it. We typically reserve 5 minutes for rebuttal, but if you'd like a different increment of time, let us know and we can adjust it. Counsel for appellant, whenever you're ready, you may approach the podium.
Before I acknowledge. Can you hear me okay?
Yes, sir.
I went back and forth and I decided I should file supplemental authority today. And the reason I did that is because I thought it would be better than waiting till afterwards and filing it. So it was definitely short notice, but it was a result of me searching a different platform.
Thank you, counsel, for acknowledging that.
Myself, may it please the court. My name is Jack Callow. I represent Work and Rest Inc., which is a small company owned by Anna Lberry. Her last name is pronounced Lberry. I'd like to first address the answer brief of defendant, but also in light of the order of the court below. The answer brief of defendant went through several objections to preservation and just supposed failure to argue against the affidavit that was used in support. There were several items of evidence presented with the defendant's counter motion for summary judgment. Only one of those items, which was the affidavit of Thompson, only one of those items presented the facts on which defendant's reply brief, answer brief depends, and that is mailing, specifically proper mailing. And that's why I'm arguing that at the same time as the order of the court below, because the order of the court below was based on proper mailing. Without getting into the detailed facts, which I know the court's already familiar with, this case involves a simple contract of insurance which named a lost payee lien holder, my client, Work and Rest Inc. They were named in the policy of insurance. When the insured vehicle was totaled, the insurance company made the proper contacts and told people they were mailing checks. My client followed up and requested mailing, didn't get a check. And the insurance company said to her, we mailed it. This is laid out sufficiently in the opening, the initial brief, and I think it's also carried through in both parties' following briefs. But then Lberry said, we didn't get it. And they said, well, we mailed it. They got a copy from the bank and sent that copy to her and said, our obligation's fulfilled. That's really the essence of the problem. We have some legal details and some legal arguments that contain a lot of different terminology, but it all boils down to someone stole your check. We're not responsible for that.
Is there anything in the policy that you could point us to that talks about whether the insurance company's obligation is discharged upon mailing, or is it discharged upon receipt by your client, or something else? It doesn't speak to that.
There's nothing in the policy that specifically says that. Pardon me. The policy does have a list of, and I I didn't bring the whole thing today. It has a list of things in which we will not protect the lien holder. And they, that enumeration of 4 or 5 things basically express the holdings of previous cases. I couldn't name the cases, but the holdings of these cases have created these terms that GEICO was very careful to specify in its, but as to the answer to your question, no, it doesn't.
Yeah, I share Judge Brownlee's question. So we're here on a breach of contract claim,
Right.
right? Did the contract obligate them to pay you, correct?
Yes,
And that's in the, I'm sorry, the loss payable clause.
that's right.
How is that, per the contract, how is that obligation fulfilled? Is there any dispute that that obligation is fulfilled upon mailing, correct mailing?
There's
is it
no
fulfilled-
provision for mailing or any other means, just payment. And that's why when Working Rest filed its lawsuit, it alleged a simple contract. A contract, a obligation. and-
Well, I guess in there, I mean, what they would argue is that payment was made, right? The address, although it may be in dispute, there was a check issued and it was issued in name to your company.
They contend that there's a check issue.
Correct. And that's not disputed, is it?
It is disputed, but it's not a major dispute that is presented to the court today, but it's not acknowledged. That's part of
That the check, sorry, it's not acknowledged that the check was written
That
and
the check-
sent?
it's not acknowledged that the check was written or that it was mailed. For purposes of argument today, it's sufficient.
Hold on, counsel. Paragraph 1 of the court's order says the parties are in agreement that the defendant timely issued a check made payable to plaintiff for a mutually agreed upon amount.
That's correct. It's correct that the order says that, but that's not based on anything in the record.
Did you challenge this? What you're saying is a false statement of the parties' agreement and a motion for rehearing?
And I don't believe so. I don't believe it's challenged in the motion for rehearing specifically, no.
But it appeared for the first time, this error you're alleging on the face of this order.
Yeah, and yes, and if you read the transcript of the hearing, there's one point where Work and Rest Counsel specifically says that we don't acknowledge the check was created. And while that might seem a little bit unusual, the reason for that is because no evidence in this case came from GEICO. GEICO, they presented documents. The check that GEICO presented in this case was obtained by GEICO in a subpoena to Bank of America. It did not come from GEICO's files. And there's no dispute about that. That's just the record.
Yeah.
There's no, we spell that out in the briefs. There's no mailing receipt. There's no record of mailing in the files of GEICO that's offered. There's no statement by the person that mailed or the person responsible for mailing. There's the statement by the Thompson affidavit, which is really the big issue.
Can you
She's the adjuster in the case,
I'm
correct?
sorry.
Go ahead,
Ms.
Judge.
Thompson is the adjuster in the case?
No.
We do have an adjuster in the case, do we
That's
not?
another unexpected answer to the court possibly, but no, Thompson relates things. She says that she's saying this on making a statement on personal knowledge, but what she relates is what the adjuster did and the adjuster said. She makes statements as to what the adjuster and Anna Lberry, the owner of Working Rest, what they said and what they did. But she never says that she's the adjuster. She says she's the current adjuster.
The
And
what? I'm
The
sorry.
current adjuster.
Current
So
adjuster.
Elizabeth Thompson was a claims adjuster. And she provided an affidavit in this case that describes mailing.
she's a claims adjuster at GEICO.
Is there any evidence that she wasn't the claims adjuster at all relevant times? I do understand that adjusters
In
change
her,
various.
yes, in her affidavit, she makes a few affirmative statements. One of which is paragraph 10, which says the check was mailed to 3470, which is not the correct address. She makes a few affirmative statements, but she makes a lot of statements which I could read, but they're easy to find. Early in the affidavit, she says that Anna Lberry gave her the address to mail the check to, 3470 Old Winter Garden Road, Orlando. So it's pretty clear from the affidavit that she's relating that from the adjuster's record. One of the problems with the affidavit is that she doesn't say that Anna said this to me. She doesn't say anyone said it to her. She says Anna told the adjuster, or Ms. Lberry told the adjuster. And the adjuster said this, and the adjuster verified this. In the affidavit, in the early part, there are a lot of paragraphs to it. And I made a list of the types of statements that she makes. But what she never makes, Thompson never makes, is a firsthand statement of what she did and what she said to or from Ms. Lberry. She says the adjuster did this, the adjuster did that. And in fact, I believe she's referring to November 15th of 2021, as the day that it's one of the early paragraphs, maybe I think paragraph 7 or 8 of the affidavit of Thompson. She says that the adjuster, I think she said that the adjuster called Ms. Lberry, and Ms. Lberry gave her the address of 3470. It says that. That's the wrong address. But the next paragraph is the general practices paragraph that says it's the general practice of GEICO to mail the check, et cetera, to the address in the mail to field. She calls it the field, which gives the impression, she doesn't say this, but she gives the impression that the adjuster is working on a computer and input. She uses the word input. So the adjuster input the correct address in the mail to field. And the general practice is that the check is mailed the next day.
Counsel, we don't know that the affidavit was made. She does not tell us, the adjuster doesn't tell us the affidavit was made based upon looking at some log kept by all adjusters in the case, correct?
She makes a reference to the file of the adjuster.
But she says it's based upon her personal knowledge. We know she's an adjuster at some point in this case. Is it not speculation that this is not her personal knowledge?
Oh, no, Your Honor. I would represent, that's not my speculation at all. It's solidly shown in the affidavit that
She's not the adjuster, that there were other adjusters and she's, sorry, I'm sorry, counsel, go ahead.
that's part of one of the defects of the affidavit. She never says when she's the adjuster, but all we know is the affidavit was made in August of 2024, I believe it was, when the 2023, when the motion of some judgment was made. The affidavit was made, I believe, in July, about 3 weeks before the defendant filed their response, their opposition, and their counter motion for summary judgment. But I don't mean to be argumentative, Your Honor, but no, she never says that she was the adjuster on the claim. She never says when she became the adjuster. There's another document in the record of the court. She signed something that may be a discovery document, and the title, it says examining adjuster Elizabeth Thompson. But in this affidavit, she doesn't say examining adjuster. She just says she's Elizabeth Thompson.
Also, is it your position that an adjuster who comes on board later in time, say we just can't find that initial adjuster anymore, but say that insurance company is certain it mailed that check and it's certain it mailed it to the right person, is there never in your mind a way for the next adjuster to make a statement in support of the insurance company mailing the check? Like, there could a subsequent adjuster say anything in the affidavit that would be sufficient to demonstrate that the insurance company did in fact mail the check?
Well, the adjuster could say whatever the record shows. That's what she doesn't do here. She doesn't say that she's stating what is in a record. She doesn't say I'm reading the adjuster's file, but she speaks in the third person about the adjuster. This is not this is not the primary issue, and we believe that this case can be decided on the pretty much what the arguments are now. That GEICO contends that it properly mailed the check. The order finds that GEICO properly mailed the check. The affidavit of Thompson does not show that GEICO properly mailed the check. She didn't say she mailed it. She didn't say who mailed it. She didn't say she even examined records, internal records of GEICO that it was mailed. What she says is what the adjuster and Ms. Lberry said to one another. And she asserts affirmatively, Ms. Lberry said this, but she doesn't say she ever spoke to Ms. Lberry. She doesn't say Ms. Lberry said it to her. So I think that, well, I kind of I got my nose down close to the paper and really examined all these addresses in each paragraph of the affidavit. And so I'm very familiar with these details, but I don't believe that's essential for the court to make a decision. What the court is faced with today is whether the affidavit of Thompson was sufficient on the standards of Rule 1.510, Rules of Civil Procedure, which requires firsthand knowledge of an affiant who makes statements admissible in court. And the issue is whether her statements are admissible, whether her statements are firsthand. She starts out saying, I have personal knowledge, then she does not make firsthand statements, except for one or two. One is, it's paragraph 10, which says, I think it was 8 says, Ms. Lberry gave us the address 3470. Then it's the practice, that might be paragraph 7, then paragraph 8 might say it's the practice to input the address that given by the lien holder, party to be paid, to input that address in the mail to field. The next paragraph says it's the general practice to mail the check to the address shown in the mail to field. Doesn't say they mailed it to 3740, which is the correct address. The next paragraph says, in this case, the check was mailed to 3470, which is the wrong address. And one might assume, I don't think we should assume anything here, but one might assume, oh, that's a mistake. That's a inversion of numbers, except that she just relates that Ms. Lberry gave her the wrong address. Then in paragraph 10, she says, in this case, we mailed the check to the wrong address. In other words, those addresses match. There's nowhere in the affidavit where Ms. Thompson says, GEICO mailed the check to 3740 Old Winter Garden Road. She says, GEICO mailed the check to the address she said it's the general practice to mail it to the address in the mail to field. I hope this isn't too confusing because it's not really what I think is before the court.
Counsel, when you began your argument, you appeared to concede that you may have a preservation issue, but it may be excused. Is that what but you didn't really develop why you brought up preservation. Can you do that?
Why I brought up what? Preservation.
When you started here today, you
Mhm.
said that my opponent is going to say or has said that some of these arguments are not preserved. Can you identify what you think they're talking about and why you think it doesn't
They're
matter?
talking about the argument that there's no proof, the absence of proof of mailing the check to the proper address. And that was preserved. And the reply brief sets out the pages. And it was preserved, and it was specifically the main argument in Workenrust's opposition to the motion for summary judgment.
What about the argument that the numbers and the address are transposed? Was that argument preserved? And does it need to be?
No, that argument wasn't specifically discussed below, but everything that composes that argument was. In the case of the Ruiz versus Wendy's trucking case that was cited by the defendant, in that case, the court gives a very careful articulation of why, I believe it's Ruiz, properly raised an argument without specifically raising the argument. They raised the legal point, but didn't articulate it in the words that were used in the objection. The court in that case said they did properly they made that argument. That party lost for a different reason, but I would refer to that. It's almost a full page discussion of what it means to preserve an error when you don't use the typical words or the precise enough words.
But was there ever a moment where you informed the trial court, hey, judge, further proof of this mailing problem is based on the affidavit and this inversion of numbers? Like, do you think that was brought to his attention at all?
Not the inversion of numbers was not brought to his attention. No, the numbers were only used once in the transcript of the hearing. And it was by GEICO's counsel, but it wasn't on that issue. That issue seems to have slipped by, but I think that the competence of Thompson to make her affidavit and the failure of the affidavit to support their motion for summary judgment or to preclude Working Rust's motion for summary judgment, I think that's clear that affidavit cannot support the court's ruling.
Thank you, counsel.
Thank you.
If you can hold 1 second. Marshall Crawford, I'm having trouble. I don't know if I need to reset. It's not giving me the. Thank you so much. Counsel, whenever you're ready.
Thank you. May it please the court. Sharon Degnan here on behalf of Kubicki Draper, representing the appellee, the defendant below, GEICO Indemnity Company. We're here today asking the court to affirm the summary judgment in GEICO's favor. And we believe this case should be resolved primarily on the preservation grounds, since the main issue that plaintiffs argued, as made clear from the argument today, as well as in the reply brief, makes it totally clear that the issue that they're addressing regarding the address in the affidavit, it was never raised or ever brought to the trial court's attention. Now, this court just a few weeks ago in the Figueroa versus Universal Property case, I believe Judge Nardella and Judge White were both on that, as well as the Florida Supreme Court, and every court in this state recognized the impropriety of parties raising arguments for the first time on appeal, even of a summary judgment order. That's exactly what the plaintiff did here. And
counsel, let me focus you on that. I heard Appellant's counsel concede that this transposition of the numbers was not brought to the trial court's attention. But what about his argument that the affidavit was insufficient to show that the affiant had the competence to testify to what the affiant testified to regarding the mailing practices, et cetera? You're saying that wasn't preserved?
I think they did challenge the affidavit in that way. And they argued that unless somebody came forward with an envelope, that they were not qualified. And some of the arguments that we heard here today, that unless it was the person that actually sent the letter, that nobody would be competent. And we don't believe that's what the law is. So that issue was preserved, challenging
The issue in whole as to Ms. Thompson's affidavit, I understand, but particularly today, that Ms. Thompson may not have been the adjuster at all times. Was that argument made below?
It wasn't worded that way. No, it wasn't. I mean, they never argued whether she was or wasn't. And, I don't know that the record even reflects that. It does talk about, though, that she has personal knowledge through looking at the claims file and being familiar with GEICO's business practice of how it mails lienholder checks. And she lays that out very closely and talks about what was done and how it was done. And then looking through the claims file, that it was done in this case.
It's my understanding of reading this record that it is not clear whether mailing took place by the adjuster, who may have input the information and printed out an envelope and put it in the window, or whether it went to some mailing center after they input the information, and then the mailing center, which may keep a lot, like, we just don't know in this case is where I came away. Is that accurate?
Well, I think that paragraph 9 of the affidavit, deals with that. And it says, with respect to the issue of mailing checks, GEICO's practice is to confirm the mailing address and any special mailing instructions with the lien holder before issuing payment. Once the mailing or special instructions are confirmed, the payment is issued. And then it goes through, the affidavit does talk about how the information is input through the adjuster, right? When they're
Right, but we
talking
don't
to
know
the
if that's
lien
taking
holder.
place in the adjuster's cubicle with the printer, printing it out, and then stuffing it, and then her giving it to the mail person, or if it's going to a mail center, which is doing all the mail for the adjusters that day. We just,
Well, it says, right, the check is then printed. I think you're probably right that it doesn't specifically say, it does talk about that the adjuster is the one talking, that's part of the practice to make sure you're sending it to the right place. And that's where the lien holder is instructing you to send it. And I think that's really an important point here, that that's really what the trial court correctly was concentrating on, that there's no dispute that the check was sent to the lien holder at the when they told them to mail it to them at that address. And I think that's very important with respect to the issue of whether GEICO complied with its contractual obligations here. Because under the policy requires them to pay the lien holder. And the question becomes, okay, well, what is payment? And that issue under Florida law, I think plaintiff's position is that it has to actually be hand delivered and reach the lien holder. And our position is that's not what Florida law says. What Florida law says is that if the parties come to an agreement where the creditor consents to payment by mail, then payment is made once the check is mailed. And that's why summary judgment was correct here. And that's, I think the trial court correctly found that. And so our position is that, the issues that have been briefed in this case are really, none of them were preserved. They're different issues. A lot of the issues that are being raised in this case are different than what was raised below. And the trial court correctly ruled based on the issues that were before him. No, one of the other issues, we haven't really discussed it here today, but one of the issues that came up are issues with the UCC. And again, whether GEICO's obligations were discharged as a result of the check being cashed. And again, and I think that issue, I was as I was planning how to address this issue, I think it's important for two reasons. One, because there was a discharge defense raised by GEICO saying, our duty was discharged when the bank cashed the check. But I think the big picture reason why that's important here is because this isn't a situation where GEICO's saying, oh, we put it in the mail and it just got lost and it was never cashed. So that's sorry. If that was our position, I think it'd be a different situation. But the fact that this check was intercepted and was actually cashed by someone, that makes it an issue that also the question becomes, where is the remedy here? And our position is that the remedy is with the bank. And I think, that is another issue that's very clear in this record, that this whole dispute could have been avoided when these situations happen. GEICO tells the party, if you fill out this fraud affidavit, and it's a Bank of America fraud affidavit that they require, and it's provided to the bank, they'll credit the money back from the person, because in this case, we know it went into some random person's bank account. If you sign that, it will be credited from their bank account back to GEICO, and they would have reissued the check. I mean, it really could have been that simple here.
Is there anything in the record that states why that didn't happen?
Well, the argument is that they were being told that they shouldn't sign it because there's an indemnity provision in there that essentially says, if you're involved in the fraud, you have to indemnify us. I don't know that that's an unreasonable circumstance, but at the end of the day, the question becomes, you could have gotten the money back. And again, I think they'd be right if the facts didn't show that the lien holder told us to send the check to that address, they may have an argument that there could be a breach of contract claim, but the law is very clear that if there's an agreement or the creditor consents to payment by mail, then at the time that the check is placed in the mail, they've complied with their contractual duty. And at the end of the day, our position is that that's why the trial court correctly granted summary judgment in this case. And the court recognized that there is a remedy here. So if the court doesn't have, hopefully my position was clear in the brief. If the court doesn't have any other questions, I'll rely,
Just one question following on what you just said. The trial court found that there was a remedy here. Do we have to find that there was a remedy for your client, an alternative remedy in order for your client to prevail on appeal?
I don't think you do. I mean, I think at the end of the day, you don't have to, although I think it sort of explains why everything that was done here is correct. And I think if you look at the different steps, it makes sense. But, plaintiff's position throughout this, they argue the UCC is irrelevant and it's a breach of contract claim and that they're required to get the money. And I think when you really boil it down the position, our position is that's not an accurate statement of law, and that where they agreed and consented to do it that way, that's the law, that once it was in the mail, we complied with our contractual obligations. So the court correctly granted summary judgment. Did that answer your question?
It did, thank you.
All right. Thank you very much. We'll rely on our brief.
Thank you, counsel. I'm sorry, counsel, but you already went into your rebuttal time. So arguments are over for today. I thank you guys for your arguments today and for your briefs that were presented on this matter. The court is in recess. Or adjourned, actually.